So today's topic is Article 21, which provides for right to life and liberty. You see, what is life? Life is not animal existence. Life is not only about survival. We want to lead a very good life, right? So we need right to life, which is more than animal existence, which is more than mere survival, right? We need happiness. We need a good environment. We want that our rights should not be infringed by any other party or any other institute or any other person. So basically, right to life is an umbrella of rights. If you see, there are so many rights which are embedded in Article 21, and judiciary has played a very active role, I should say, in expanding the scope of Article 21. You see, there's a concept called as transformative constitutionalism, which says that a constitution is transformed as per the needs of the society, and at the heart of it lies the Article 21. Why? Because it keeps evolving as per the needs of the society. You see, right to privacy. Earlier, it was not a fundamental right, but thanks to Supreme Court, they gave us the right to privacy. We'll be discussing the case laws ahead. So Article 21 is an ever evolving right, and it will keep on evolving, and we'll be having more such rights in Article 21. So Article 21 says that no person shall be deprived of his life or personal liberty except according to procedure established by law. We had a small talk on life, and we'll have a small talk on personal liberty as well. What is personal liberty? Well, personal liberty is a freedom to act on your own will. It is a freedom to act on your own will. But this freedom is not absolute. Why? Because there are certain restrictions, and it can be restricted according to procedure established by law. So there are so many rights embedded in Article 21, and we'll start with the personal liberty. So we have shared a PDF, a document in which there are landmark cases on Article 21. It will be like a storytelling session which talks about different rights pertaining to Article 21. So I hope you have all your ears in for this particular session. And to begin with, we'll discuss first with the personal liberty, and under personal liberty, we'll be first discussing the A.K. Gopalan versus State of Madras case, right? So A.K. Gopalan was a communist leader, and during 1950s, there was hardly any opposition, and Communist Party was one of the opposition to the Congress Party. So Communist Party was having a feud with the Congress Party, and there were elections coming on in 1952. So there were tension between these two parties. So A.K. Gopalan, being a communist leader, was arrested under Preventive Detention Act 1950. Preventive Detention Act 1950. He challenged his detention that my detention is against Article 21 as it takes away my right to life and personal liberty. You see, A.K. Gopalan at that time was a communist leader. Then in 1952, he won the elections. He became the member of parliament. He played an active role in establishing ICH as well. If you know Indian Coffee House, it is a cooperative society. So he played a very active role in establishing the ICH as well. And he was of socialist, more of a socialist thinker. So there was ideological differences between the Communist Party and the Congress Party. Congress being the centrist political party, and Party being on the left side. So A.K. Gopalan was arrested under Preventive Detention Act 1950. Preventive Detention Act 1950 is a preventive detention act which provides that if any person is a threat to integrity of India, to security or integrity of India, or if he comes out and speaks something, he can be preventively detained and stopped from doing such activity, right? So he was arrested under the Preventive Detention Act 1950, and he called it that my detention is unconstitutional. Why? Because it violates Article 21. At that time, Constitution was very much new. Why? Because in 1950 it got ready, and this case was in 1951. So the Supreme Court interpreted Article 21 with a very narrow scope, I should say. It said that the Preventive Detention Act is a procedure established by law. It is a procedure established by law, and thus preventive detention of Mr. A.K. Gopalan is perfectly constitutional. Why? Because if you see at the Article 21, it provides that one can deprive of life and personal liberty according to procedure established by law. Thus, the Supreme Court held that Preventive Detention Act 1950 is the procedure established by law, and thus the preventive detention is perfectly valid. Later on, later on another case came, the Collins case, Collins case, in which it was held that procedure established by law must be reasonable. So you can see that Constitution began to evolve, or I should say, the judiciary started interpreting the Constitution and transforming the Constitution as well. Coming to the second case, which was Khadak Singh versus State of Uttar Pradesh, in which the police was conducting domiciliary visits. Now, what is domiciliary visits? Basically, these are visits conducted by the police on habitual offenders, right? They can come and scrutiny at any time. This was very common in states of Bihar and Uttar Pradesh back in 1970s and 80s. So Khadak Singh was a habitual offender, and he was arrested for dacoity, but later on he was released because there was lack of evidence. But still, police knew that he was a habitual offender. So police used to conduct the domiciliary visits in order to keep him under surveillance. They used to come and they check what he is doing, what he is up to, and specifically they used to conduct domiciliary visits at night. So Khadak Singh challenged the UP police regulations, which provided for the domiciliary visits. He said that this is my violation of right to privacy, and it is infringing my personal liberty as well. The court, however, said that right to privacy is not a fundamental right back then. Right to privacy is not a fundamental right back then, but it said that these domiciliary visits are against personal liberty, and it held that the UP police regulations cannot conduct the domiciliary visits, and these are unconstitutional. Coming to the third case, which is also called as the habeas corpus case, the ADM Jabalpur versus Shivkant Shukla case. This I call it as a black mark on our judiciary, or it is a black mark on our democracy as well. So Shivkant Shukla was a journalist who was critique of Mrs. Indira Gandhi, and Shivkant Shukla was arrested under the MISA Act, the Maintenance of Internal Security Act, 1971. So, being the critic of the government is power is itself a crime, not as per a good democracy, but as per the ruling party or the ruling government themselves. So he was arrested under the MISA Act, Maintenance of Internal Security Act. There are so many journalists who get arrested under various preventive detention acts, and Shivkant Shukla was one of them. But at that time, during his arrest, there was emergency going on, the 1975 emergency, which was declared on ground of internal disturbance. And so Shivkant Shukla challenged his detention that it is against my right to life and personal liberty, and it is also against the fundamental freedoms which are provided under Article 19. So the Madhya Pradesh High Court gave the decision in favor of the Shivkant Shukla. They said yes, that his preventive detention is violative of Article 21, and he should be released immediately. But against this decision, the government came before the Supreme Court. Now, before the Supreme Court, the major question was that during operation of emergency, fundamental rights shall be suspended or not. shall be suspended or not. So back then, the Supreme Court said that yes, during operation of emergency, fundamental rights shall stand suspended. Thus, what does this mean? This means that if you are arrested, you cannot even go to court for your release. Why? Because during emergency, your fundamental rights shall stand suspended, which is why I say that this is a black mark on our judiciary. This judgment was not reasonable, and it gave excessive power to the ruling government. So the Supreme Court set aside the judgment of the High Court and told that yes, during operation of emergency, fundamental rights shall stand suspended. So there were 5-judge bench sat in this particular judgment, and the judgment came 4:1. So I'm giving you the task that who gave the dissenting judgment in the ADM Joel versus Shivkant Shukla case. He is a very celebrated judge, and his judgment is still now, though being the dissenting judgment, it is still now adored by many of the practicing advocates. So I hope these 3 cases are clear to you, so that we can move ahead. Can we have the next page, please? Yes. So the next landmark case is the Maneka Gandhi versus Union of India. You see, during late 1970s and early 80s, before assassination of Mrs. Indira Gandhi, Maneka Gandhi was having a feud with her mother-in-law, Mrs. Indira Gandhi, the then Prime Minister. And Maneka Gandhi wanted to travel abroad. Being a journalist, she wanted to travel abroad. But she received a letter from a regional passport officer that she needs to submit her passport within 7 days. So if you submit your passport, definitely, obviously, you cannot travel abroad. And this was ordered to her as per Section 10(3)(c) of the Passport Act of 1967. So Maneka Gandhi challenged it that this is against her personal liberty. Why? Because her freedom to act on her will was being violated. Why? Because passport officer wanted to submit her passport. So Maneka Gandhi immediately challenged this before the Supreme Court that this Section 10(3)(c) of the Passport Act 1967 is violative of Article 21, and her freedom to move abroad is being violated. The court held that Section 10(3)(c) of the Passport Act is void because it violates Article 14. Why? Because it provides arbitrary power to the state that you should submit your passport, and you won't be furnished the reasons that why you are being asked to submit your passport. In interest, it was written in Section 10(3)(c) that in interest of general public, you shall not furnish the reason that why you need to submit your passport. This gives unreasonable power to the executive that they can ask anybody to submit their passport, and they shall not furnish the grounds on which they are asking to submit your passport, right? So the court held that Section 10(3)(c) gives arbitrary powers to the executive, to the state, and thus it is very vague, and it gives undefined power to the passport authority. And moreover, it is violative of Article 14, 19, and 21, the Golden Triangle, right? And moreover, it did not give, or it did not follow the principles of natural justice. You see, in the earlier case of Khadak Singh, it was held that principles of natural justice are not part of Article 21. But this observation was overruled in the present case, Maneka Gandhi versus Union of India, in which it was held that principles of natural justice are part of Article 21. So now the question comes, what are principles of natural justice? There are 2 principles: nemo judex in causa sua, which provides for right against bias, and second is audi alteram partem, which means the person has right to be heard. So in this case, it was held that principles of natural justice are part of Article 21, and you need to hear the other party before doing something which violates his rights, right? So in this case, it was held that it was violative of Article 14, 19, and 21, and it does not provide an opportunity for the aggrieved party to be heard. And it also brought principles of natural justice within the ambit of Article 21. You see, the rights are being evolved. Earlier in the Khadak Singh case, it was held that no, principles of natural justice are not part of Article 21. But later on, in late 1970s, it was held that principles of natural justice are part of Article 21, and it stands as of now that principles of natural justice are part of Article 21. Can we have the next page, please? Right. Coming to another right, that is right to privacy. I'll start with the Khadak Singh case. We discussed it earlier. In Khadak Singh case, it was held that right to privacy is not a fundamental right, right? But this view was changed in two cases, UIDAI versus CBI and KS Puttaswamy case. In KS Puttaswamy case, it was clearly mentioned that the Aadhaar card case, it is also called as the Aadhaar card case, it was clearly mentioned that right to privacy is part of Article 21. So we'll discuss the first case, that is UIDAI versus CBI. So CBI was investigating a rape case involving a minor girl, and they were not getting any such evidences. However, they had some fingerprints. So they wanted that these fingerprints must be sent to UIDAI, which is the Aadhaar authority, and UIDAI shall match these fingerprints with their data and inform CBI that these fingerprints belong to these particular persons, on which on these grounds they can at least reach to some of the suspects. But UIDAI refused the CBI request made by the CBI and said that they cannot provide this particular data. However, this matter came before the Supreme Court, in which the Supreme Court said that the data with UIDAI cannot be accessed by any other authority without their permission. So the biometric which is saved, my biometric which is saved with the UIDAI, any institution, any authority cannot access it without my permission. Moreover, the Supreme Court also suggested that it would be violative of right to privacy, and a committee needs to be formed which will make some guidelines or bring up some guidelines which can provide for what purposes the data with UIDAI can be used. So you see, right to privacy is being evolved under Article 21. Then the next case, the Aadhaar judgment case, in which the government mandated that we need to submit the Aadhaar and Aadhaar card for getting any of the government incentives, and we need to submit it with bank as well. We need to link it. So Justice K.S. Puttaswamy retired. He was the High Court judge of Karnataka High Court. So this case was brought by him against the union challenging the government Aadhaar scheme. In this case, nine bench judge, nine bench constitutional bench sat and gave their judgment that right to privacy is guaranteed under Article 21, and it is an independent fundamental right. The bench also recognized that right to privacy is intrinsic part of right to life and personal liberty, and they held that there is no compulsion as to provide Aadhaar for availing any of the government schemes. So in Khadak Singh case, back in 1960s, right to privacy not part of Article 21, not a fundamental right. In UIDAI versus CBI, okay, right to privacy may be part of Article 21, may be a fundamental right. But in case Puttaswamy case, right to privacy is a fundamental right. So you see, constitution or interpretation of constitution is being transformed to meet the needs of the society, right? Then next comes the right to free legal aid. These are the two cases, MH Haskot versus State of Maharashtra and Husnera Khatun versus State of Bihar. These are the two cases which are the basis for the I should say, legal aid, or the government or the state started thinking about the setting up the Legal Services Act, Legal Authority Services Act. So in under M.H. Haskot versus State of Maharashtra, the petitioner M.H. Haskot was a PhD student, and he was alleged that he committed fraud and forgery. He was into uh, he was into making fake mark sheets and fake degrees for Mumbai University, right? So the session court found him guilty, and same was upheld by the High Court, and a total of 5 years uh, imprisonment was awarded to him. But after 4 years, he brought SLP before the Supreme Court. But Supreme Court was surprised, not surprised, surprised that there was 5 years of imprisonment which was awarded to you, and you are coming here after 4 years. What's the matter? To which he replied that he did not had adequate means to come before the Supreme Court. He cannot afford to come before the Supreme Court. To which the Supreme Court emphasized that there is a need of free legal aid. There are so many persons who are deprived of their rights just because they cannot afford to bring the matter before the court, right? So Supreme Court held that free legal aid is state's responsibility, and it is not a government charity. So this case and the Husnara Khatun case became the basis for making the Legal Services Authorities Act, which was enacted in 1987. It provides for establishment of NALSA. It provides for establishment of SLSA, that is State Legal Services Authority, and it provides for establishment of DLSA, which stands for District Legal Services Authority. What they do is they provide free legal aid to the person who cannot afford it, right? So the next case is Husnara Khatun versus State of Bihar, which provides for right to speedy trial. Speedy trial is part of Article 21. After this case, there was amendment in CRPC as well, and the concept came of the default bail. Default bail, right? So a PIL was filed before the Honorable Supreme Court by Kapila Hingorani. If you don't know Kapila Hingorani, she is also called as the mother of PILs. She is also called as the mother of PILs. So a PIL was formed to free the under trial prisoners, and Husnara Khatun was one of the under trial prisoners. It was contended by the petitioners that there are so many under trial prisoners which are imprisonment for a longer term than they actually deserve. For example, for theft, there is a punishment of 3 years. Being the under trial, I am not convicted. I am only accused, and I am into prison for 5 years. But the actual punishment for theft is only 3 years. So you see, there were under trial prisoners who were subject to more imprisonment than they deserved, right? That too being the under trial, that too being the accused, not being the convicted. So in this case, the Supreme Court explained uh, and emphasized on Article 39A, and it recognized that right to speedy trial is part of Article 21. And these two cases form the basis for the Legal Services Authorities Act in 1987, which I clearly stated that this act provides for three establishments which are into providing the free legal aid. Can we have the next page, please? Yes. Then there are some prisoners' rights which are also part of Article 21. One of the most, if you have ever read the administrative law, you will always come across the Sunil Batra versus Delhi administration case law. In this particular case law, Sunil Batra was a convict. He was awarded with death sentence, and his friend Premchand was subject to unreasonable assault by the head warden of Tihar Central Jail, and he informed this particular matter to the Supreme Court by a letter, and Supreme Court admitted this particular letter as a writ petition of habeas corpus. So you see the ambit or the scope of habeas corpus is also getting expanded, right? So there is no particular format which is required to file the writ of habeas corpus. They treated that letter of Sunil Batra informing that there is unreasonable assault on my friend Prem Chand as a habeas corpus writ. So you see, the the writ of habeas corpus or the scope of habeas corpus is also getting expanded. So the court observed that court has and the power and responsibility to intervene and protect the prisoner against any unreasonable assault or any unreasonable infliction of harm or infringement of rights. You see, so the writ of habeas corpus is not only available to us being the free citizens, but it is available to prisoners as well. So they, even if they are imprisonment, they have minimum set standard of rights and state cannot infringe it. So court in conclusion held that Premchand was tortured illegally and the superintendent cannot absolve himself from the responsibility. The jailer was inflicting harm on the Premchand, and it is the responsibility of superintendent that these acts should not be performed in the jail. The Supreme Court also directed the SP that no corporal punishment or personal violence shall be inflicted on Premchand or any of the other prisoners. So by this case, the scope of habeas corpus was expanded, and now some degree of, or I should say, the restricted degree of fundamental right as to right to life and personal liberty is available to prisoners as well. Then the next case is Prem Shankar Shukla versus Delhi administration, again a landmark case. In this is also called as the handcuffing case. Prem Shankar Shukla was accused of minor offenses, but he was subject to handcuffing, right? And the magistrate clearly directed, he pleaded before the magistrate that he should not be handcuffed. And the magistrate directed the police that he should not be handcuffed. But despite of these directions, he was being handcuffed, right? So he challenged his handcuffing before the Supreme Court that this is against my right to life and personal liberty, even though he was a prisoner. But as I said earlier, that they also have certain degree of freedom to enjoy, right? So he sent a telegram to the Supreme Court that despite of the magistrate's direction, I am being handcuffed. So in this case, the telegraph or telegram, whatever it is called, was also treated as the writ of habeas corpus. That communication was also treated as the writ of habeas corpus. The Supreme Court held that handcuffs are prima facie inhumane, and it is blush arbitrary without fair procedure and objective monitoring. Okay, fine, you can do handcuffs, but only if it is found reasonable. If they are habitual offenders, if they have done some heinous offenses, very serious offenses, fine, handcuff is required, but not in case of petty offenses. So in this case, Supreme Court held that minimum freedom of movement to which a prisoner is entitled under Article 19 of the Constitution could not be curtailed by applying handcuffs, and it was directed that Prem Shankar Shukla should not be handcuffed. Prem Shankar Shukla should not be handcuffed. So you see, these prisoners also have right to enjoy a restricted or a minimum standard of right to life and liberty. Yes, then comes the another right called as right to die. Do we have right to die as a fundamental right? The answer is we don't have right to die, but we have right to die with dignity, right? So we don't have right to die, but we have right to die with dignity. I'll explain these particular terms. So the first case was Aruna Schonberg versus Union of India. Aruna Schonberg was a nurse at KEM hospital who was subjected to sexual assault by one of her colleagues, and she went into PVS. Now, what is PVS? PVS is basically permanent vegetative state in which the body of the patient survives, but their brain is dead. Their brain is dead. So it she was kept alive for around 40-45 years artificially, right? So Pinky Virani filed a writ petition that she that she subject to cruel treatments, and she should be free to die in peace, right? And she should not be subject to cruel treatments. We should not keep her alive artificially, right, on ventilators or feeding through injections or any other. Basically, she was not enjoying her natural life, right? So this was the case of passive euthanasia. Now, what is passive euthanasia? There are two types of euthanasia: active euthanasia and passive euthanasia. Active euthanasia is when you give some poisonous substance or sedate the patient by injecting some substance which results in his death, right? And passive euthanasia is withdrawing of I should say withdrawal of the life support system, that is called as the passive euthanasia. So in active euthanasia, you deliberately inject something which results in the death, and in passive euthanasia, you withdraw the life support system. If the patient is able to survive, it's fine. If not, let them die in peace. So Pinky Virani wanted Aruna Schonberg to die in peace. Why? Because it was around 30-35 years. She did not respond, and she was in PVS, permanent vegetative state. Her brain was dead. So in this was the first case in which passive euthanasia was partially allowed, and the Supreme Court held, okay, fine, we would constitute a team of doctors who would first medically examine Aruna Schonberg, and if they are of the opinion that yes, PVS can be passive euthanasia can be allowed, we will allow the passive euthanasia. But in another instance, the other nurses of KM hospital came forward and told that we will take care of Aruna Schonberg and we will let her die naturally. We will then after 2 years in 2014, she was suffering from pneumonia, acute pneumonia, and she died a natural death. So this was the first case in which passive euthanasia was partially allowed, the case of Aruna Schonberg versus Union of India. Then the next case is common cause versus Union of India, in which the concept came of a life will. You see, we make will of property that after my death, I bequest my property X to my wife, to my children, to my brother, whatever. But you see, you can make a life will as well, or a living will as well, that in which you can write that if my 70% body gets paralyzed, I may be allowed to die. Please do not keep me artificially alive. I'm just giving you an example. So in 2005, Common Cause, which is an NGO which is actively involved in securing of human rights, came before the Supreme Court, and they asked that right to die with dignity should be declared as a fundamental right. You see, when a person is disabled or uh, suffers some disease or some other disability, he gets dependent on the other person, right? So his dignity gets infringed, or I should say gets affected, right? Why? Because you are dependent on someone else. So Common Cause wanted that right to die with dignity should be declared as a fundamental right. So it was prayed that court to issue direction to union government to allow terminally ill patients to execute living wills for appropriate action in the event that they are admitted to the hospitals. I'm just telling you that these living wills provide that if you suffer from some venereal disease or you get terminally ill, in which it is impossible or next to impossible to recover. So rather than being the subject to cruel treatments and artificial upkeep of my life, let me die in peace. Let me die in peace. So in this case, the five judge bench comprising uh, uh, in this case, five judge bench held that right to die with dignity is a fundamental right, and you can execute your living will provided you are terminally ill patient. Provided you are terminally ill patient. So we do not have right to die, but we have right to die with dignity. So if you get terminally ill, you get dependent on someone else, which adversely affects your dignity. So in this case, you may be allowed right to die with dignity. I hope I am clear with my these two cases, right? And we have the next page, please. Then comes another right, that is right to sleep. You know, during the India Against Corruption movement back in 2011-12, Ramdev Baba was opposing the government to bring back the black money, right? And they were protesting at Ramlila Maidan. So in June 2011, Ramdev Baba went on hunger strike to demand that an ordinance should be enacted or maybe brought by the government to bring back the black money which is deposited in the bank accounts abroad. So on 4th June, the permission to protest on Ramlila Maidan was withdrawn and section 144 was imposed during that protest. On 5th June, right, on 5th June 1 a.m., which means at night time, the police approximately 5,000 personnel, 5 to 7,000 personnel reached Ramlila Maidan and to evict the protesters. This is a very famous instance when Ramdev Baba wore salwar kurta and salwar suit, not kurta, salwar suit, and he ran for his life so that he should not get arrested. So in this case, the court took suo moto action against the incident and held that right to sleep peacefully is part of Article 21. Okay, fine. You could have taken the action to evict the Ramlila Maidan because the permission was withdrawn, but there was no need to act at 1 a.m. when every protester, including Ramdev Baba, was sleeping. So, in this case, the court held that the protesters had right to sleep, and right to sleep is a part of Article 21, and it also ordered that victims shall be compensated. Then the next case is right to medical aid. The case is Parmanand Katara versus Union of India. The next right is right to medical aid. The case name is Parmanand Katara versus Union of India. Parmanand Katara, he is a practicing advocate in Lucknow. So he filed a PIL before the Supreme Court on basis of a newspaper article which read that there was a death of a scooter rider who met with an accident and died because he was not able to get medical treatment on time, right? So because there used to be so many formalities, right? Police report लिखाओ और उससे पहले उसका examination, from where he came, there was some form baro, there were so many formalities. So Supreme Court held that right to medical aid is part of Article 21 and preservation of human life is of paramount importance. The other formalities can be done afterwards. First, you save the human life, right? Writing reports or any other formalities can be done afterwards. But first, the doctors should the doctors should focus on preserving the human life. The Supreme Court also relied on Code of Medical Council, which provides that doctor, whether they belong to private hospital or government hospital, they cannot deny the treatment, and they should extend their services to protect the human life. And that's how right to medical aid also became the part of Article 21. Yes, can we have the next page, please? Yes, moving on. The latest set of rights, that is right to sexual autonomy. In this case, in this, right, first we'll read about Navtej Singh Johar versus Union of India, which you all know, which this decriminalized Section 377. But this was a process. It was not an overnight win for the LGBT community. This was a process. So this process started in 1994. In 1994, when AIDS Bhedbhav Andolan came before the Supreme Court to asking that Section 377 should be scrapped. But at that time in 1994, the PIL was rejected. Then in 2004, NAS Foundation came before Delhi High Court asking that Section 377 should be scrapped. But at that time, the Delhi High Court refused to entertain their PIL on ground that NAS Foundation did not had locus standi. Now the question comes, what is locus standi? Locus standi is a right to bring action before the court. So in this case, the Delhi High Court told that NAS Foundation did not had locus standi, they did not had right to bring action before the court. Against this order, NAS Foundation went to appeal before the Supreme Court. And Supreme Court ordered the Delhi High Court that NAS Foundation has the locus standi and you need to hear their petition. Then in 2009, in the NAS Foundation judgment, the Delhi High Court said that Section 377 is unconstitutional. Why? Because it infringes personal liberty, right, and sexual autonomy of the LGBTQ community back in 2009. But then in 2013, an astrologer called as Suresh Kaushal and other religious institutes appealed before the Supreme Court. And this Delhi judgment was overruled. And thus, Section 377 was recriminalized. But then again, in 2018, Navtej Singh Johar, who was a choreographer and he himself belonged to LGBTQ community, he challenged the Suresh Kaushal versus NAS Foundation judgment on ground that Section 377 infringes their sexual autonomy and they have right to choose partner, and it is part of Article 21. Just before this case, few months back, there was another case called as Safia Jahan case, in which it was held that every person shall have right to choose their partner. So, forming basis or taking the basis of the Safia Jahan case, Supreme Court held that Section 377 is unconstitutional as far as it violates the sexual autonomy of LGBTQ community and violates fundamental right to choose the partner. And thus, this is how Section 377 got decriminalized, and it was also orally said by the Supreme Court that we owe an apology towards the LGBTQ community that they are being suppressed or their rights are being violated for so long. Then the next case is Joseph Shine versus Union of India. Joseph Shine, being NRI Keralite, he filed a PIL before the Supreme Court challenging the constitutional validity of adultery law, that is Section 497. So under this case, if you look at Section 497 of the IPC, it provides that the third person, if there are two persons, A, B, and C, A and B being the husband and wife, and if wife B is involved with someone C, C is liable for adultery and he can be prosecuted and punished for adultery. You see, this is in a same act, both are involved, women and man is involved, but only man is being punished for adultery, right? So there was violation of Article 14 because man and women were not equally treated. So in October 2017, a non-resident Keralite filed a PIL under Article 32 challenging the constitutional validity of Section 497. The court observed that law is based on societal presumptions. What societal presumption? That it is the fault of man if he gets involved with some other married women. And moreover, if someone is not happy in their marital life, they cannot have any outside affairs. But this scenario is not applicable to man. Why? Because if a married man has an extramarital affair with another woman is not being punished. But same, if a woman has an extramarital affair with a man, that man can be prosecuted under section 497, the adultery law, right? So the Supreme Court held that section 497 is archaic, and it is arbitrary, and it is against equality. Why? Because it discriminates for the same act between man and a woman. And it held that husband is not master of his wife. Thus, section 497 is no longer a criminal offense, but it stands as a valid ground for seeking divorce. But it stands as a valid ground for seeking divorce, but it is not a criminal offense anymore. So these are, as I said earlier, that Article 21 is an umbrella of rights, and there are so many rights under Article 21, and Article 21 will further get evolved. If you know some of other rights, please inform me as well. One or two rights I know, that is right to wholesome environment, right to access the internet, but it is part of Article 19, freedom of speech and expression, but it can be included in this as well. There was a Czech jurist called as Karel Vasak. He gave us that there are generations of right. First generation right being the civil political right, second generation right being the social cultural right, and third generation right provides for the social security, right to education, right to health, these rights. All these rights are getting involved. We will get to see fourth generation, fifth generation rights. But post third generation, all the rights which are covered by fourth and fifth generation will come within the ambit of Article 21. Most of the rights will come within the ambit of Article 21. So the nature of Article 21 is ever evolving. We have seen it evolve over last 75 years, and we will see it evolve for more 175 to 75 years to come.
So the participant is asking, can you shed some light on the High Court's judgment on the stray dogs, feeding the stray dogs case?
Yes. So you see, you have right to life and personal liberty. You have right to life. Similarly, they also have right to life. The problem of stray dogs is more in gated societies, right? And the High Court, various other high courts, and the Supreme Court have clearly mentioned that there needs to be some space. There needs to be some space where they can be fed properly, right? Moreover, dogs are territorial animals, right? So you cannot move one dog to another state or to another area or to some other place, right? Because they are domiciled there. You see, so uh, the only solution for this problem, that they should be sterilized, their population should be reduced, not by killing themselves, but by sterilizing them. And there should be I suppose some sessions should be held for inclusiveness. There are few people, there are some incidents where dogs bite and mishap happens, but there should be sessions for inclusiveness, that people should be made aware that how you should treat a dog. You are civilized, not the dogs, right? So it is your duty to uh, to make other uh, person feel safe, and there should be some sessions on inclusiveness, that how a dog should be treated or how dogs should be treated.
Yeah, when you began, when you started with your discussion, you said there's a golden triangle of Article 14, 21, and Article 19, sir.
Yes.
Now, my point one is if we could elaborate on that. And secondly, I would like to understand Article 21 is right to life. Now, how far a right to life is valid when we live in a cooperative housing society, and in and day out, the managing committee and upwards, they violate our right to live, life, which is justified peaceful living. Be it the managing committee, be it the quasi judiciary, be it the judiciary, and a common member is having.
Fine. Talking first is about the golden triangle. what is golden triangle? 14, 19, and 21. Why these are called as the golden triangle? Because they are so intermingled with themselves. For example, if I arrest you without providing you valid grounds, right? So firstly, it is violation of what? Violation of Article 21. Why? Because I'm infringing your principles of natural justice by not providing you grounds of arrest. Secondly, if you are arrested, your freedoms are being your freedoms are being infringed. Why? Because you do not have right to movement, you do not have right to speak, and other freedoms. Fourthly, this act is itself arbitrary. This act is itself arbitrary, right? So these rights are called as the golden triangle. Why? Because they are so intermingled with each other. If you infringe one right, it will result in infringement of other right, which will eventually result in infringement of other rights as well. Coming to your second question, the society or any other authority cannot make any laws, bylaws, which are against their parent act and which are against the constitution. So I'll just give you an example. I live in a gated society, right? So recently, my society made laws that you cannot feed stray animals, not stray dog, stray cows, or any other animal. You cannot feed them. So they cannot make such laws. Why? Because the constitution or any other law does not permit them. Does not permit them. I have my duty towards animals. Why? Because it is written in the constitution, it is written in the fundamental duties, right? You have duty towards environment. They are part of environment. Fine. So I'm just giving an example that these laws are in effective, unconstitutional, and they cannot be enforced. This is basically delegated legislation. So delegated legislations cannot be against or in violation to the Parent Act, and moreover, it cannot be in violation to the Constitution. I hope I have answered your query.
No, sir, my query was, I'm not asking about the society making laws. I'm asking about the committee and the quasi judiciary violating already made laws and a common man being harassed for the judgment. That's
Common
it.
man being harassed for the you see, if any committee or quasi judicial authority, they are also bound by fundamental rights, right? So they cannot absolve themselves that there are instances in which executive authorities abridge your fundamental rights. So you can anyway plead before the court for if your rights are being infringed. Just you need to prove why and how your rights are being infringed.
Okay, according to right to life, we also have the right to forget. If in case there are some incidents which are caused in the past and they are not going to make much effect to the society in future,
Right,
so such data
right
which
to
is held
forget.
by the right to forget,
Okay,
right to
okay,
forget by like some institutes, they hold our data, or even the judiciary or a police machinery, they hold the data which is not like somebody has made a frivolous complaint, but it is recorded in the police station. That data should be removed permanently if it is a frivolous
okay,
system. It is recorded in the frivolous nature.
okay,
These
okay.
data are maintained lifelong.
Yes, yes,
So right to forget should be activated, and such data which is not going to cause any problem to the society, whether it is judicial decision or administrative decision or any financial activities done by a particular person
yes, yes,
in
yes,
past, and it should not be held as a landmark or a distinct benchmark to decide further decisions. Like if somebody at the age of 21 has made some
yes,
financial commitment and he failed in that, but later on after
yes,
30 35 he goes for a bank loan, the bank says that
yes.
in
I
past
get your point.
when he
I
was,
get your point.
yeah, yeah, so such
Yes,
things will cause a permanent damage to his life till he survives.
yes, yes, yes.
So
I get
right to
that.
life
I get
should
your
also
point.
provide that. Yeah, please.
Yes, I'll answer this.
Thank you very much.
You see,
Yeah.
fundamental rights are available only against state. What you are saying, I completely agree with you. But if a record is maintained by a private entity, so you cannot question it on the ground that it is against my right to life and liberty. I completely get your point. But if this is a police record, if this is a record maintained by state, then your right can be exercised, but not with the private entity. The thing which you are talking about, I completely agree with. But there would be bifurcation on the information, whether it is maintained by a private entity or a public entity, state, or by some state, then your right can be exercised, but not against the private entity. I get your point. Yes.
Okay, it means that the private entity is holding my data.
Yes,
She
it can
cannot
hold.
erase it.
No. And moreover, judiciary or any other authority cannot make him to delete it.
Okay, but what is happening is with that, they are accumulating the data and selling it in the open market, which is again
Yes.
injuring the right to privacy.
Yes.
Yeah,
This
these
is
numbers,
this.
then this should also be
These are,
curtailed.
yes. These are two different things. First
Yeah.
is saving your data. It is perfectly
Yeah.
fine. But when you use that data for some other purpose, that can be restricted. Yes.
Okay, because it's, and one more thing, right to peaceful life. I don't know
Yes.
how IRDA has passed the orders to give marketing permission to these telemarketing people, wherein there is no person speaking to you. The moment you pick up the call, there is a recorded message going on. This is a
Yes.
new scam, and I don't know how government is allowing it to and get people disturbed day in and day out.
Yes.
The moment you
Yes.
pick up a
Yes.
call, there is a recorded message running,
Yes. I get that.
and it
I
is
get that.
yeah. So I think this thing right to peaceful life is getting injured with this.
Yes. But
Yeah.
I again, there are private banks and there are public banks. You will hardly receive it from public banks, but you will receive
Yeah.
so many calls from private banks. They are
Yeah, not
now
private
see
banks,
the
even Club Mahindra type or
public
something.
banks.
Sorry, I'm naming somebody.
Okay.
It's not allowed.
Okay.
Like X company, they
But
keep on calling for marketing
the
calls.
thing is, they also have a right to right to occupation, right to be in some profession, right to
Yeah,
do business. So if you
at the cost of
well, there are
general
two
public.
sides of a coin. Yes, there are two sides of coin. They will say that we have right to exercise our profession, right to conduct our business, and you will say that we have right to lead a peaceful life. So
Yes.
balance is required between these two rights. And how
Yeah.
that balance is secured, when you complain them that I don't want to receive your calls, they will just say कि भैया ये हमारा कस्टमर केयर का ईमेल है, ये कस्टमर केयर का नंबर है, आप बोल दो आपको
Hmm.
कॉल नहीं आएगा. So
And that's not working. That's not working because they say we have thousands of people working. If I don't call, somebody else will call, and it is open in our
I
entire
completely get
office.
you. I completely get you, and
Yeah.
I get disturbed by these calls as well. But
Yeah.
they tell me कि आप मेरे
Even
को जो है yes
even NDNC is not working. It's a dysfunction now.
execute
KRA has discontinued giving at NDNC.
there are lacunas in part of execution of DND, but
Yeah.
on this premise, whole banking sector, whole insurance sector cannot be stopped from conducting their marketing activities.
Yeah. So I think a PL can be filed for this.
Yes, it can be filed.
Yeah.
Definitely, it can be filed, but I don't think so. It will be entertained for much long time.
Yeah, but yet can be given a try.
Yes, definitely.
Thank you very much.
So a participant is asking, is there a law on honor killing in India?
There is no I think there are some state laws on honor killing. I guess Haryana has some law on honor killing, but as to any central law, I don't think so. There are some certain guidelines. The Safia Jahan case which I talked about was for honor killing, in which right to choose a partner was recognized. Khap
Okay.
Panchayat, it was also called as the Khap Panchayat case.
So nextly, the participant wants to know what is meant by assisted killing.
Assisted killing is active euthanasia. Assisted killing is active euthanasia. Active euthanasia is not allowed. It is illegal. Only passive euthanasia is allowed. Assisted killing is when a person wants to die and I inject some poison, I inject some toxic substances which results in his death. That is assisted killing. But we in India, only passive euthanasia is allowed. There are certain European countries in which assisted killing is allowed. Sweden, Denmark being the one. But in India, we only allow passive euthanasia. That is, when the person is in permanent vegetative state, he is not able to respond. We just withdraw the life support system. If the patient is able to survive, it's fine. If not, then he's dead.
Okay. The next question is, does domestic violence fall under the purview of Article 21?
Domestic violence. You see, your husband or your wife is the private entity. Fine. So they are not state. So definitely that this is infringement. Uh, these are private wrongs. There is infringement of your life, but these are private wrongs. So they won't be covered under the Article 21.
Okay, sir. So with this, we are done with the queries. Can we end the
Okay.
session, sir, with your permission?
Yes. Thank you. It was
Okay.
great having a session with you guys.
Thank you so much, sir, for such an illuminating talk. It was a great session. Hope to see you again. Thank you, sir.
Thank you.